All right, so let's talk about business litigation, contract disputes. So when someone says litigation, that just means basically taking someone to court because of some kind of dispute that needs to get resolved by someone else, like the court. So when it comes to contract disputes, business disputes, that's a business litigation attorney. So when you think about hiring a business litigation attorney, one of the things you have to think about is how are they going to get paid? So if you have some kind of issue with between you and some other business or a dispute over a contract, usually it's going to be over a certain amount of money. Okay, they didn't pay or they did something that hurt me. Those are called damages, monetary damages. So you have to figure out, okay, what are my damages? Am I suing just because I'm mad, which is never a good idea? Or am I suing because here's what they did, and as a result, here's how I was damaged? And you need to be able to prove your damages. So if you can prove your damages that, yes, because they, didn't do what they were supposed to marketing wise, I lost a client. The client said, hey, because of this, what you guys messed up, I didn't hire you and you guys lost $100,000 job or project, let's say, okay, so you've got maybe $100,000 in damages. So that's one of the first things you have to figure out. What was the thing that we're disputing over and what are the damages? So if you want to talk to a business litigation attorney, that's one of the things they're going to drill down on is, okay, what are the damages? Because most business litigation attorneys, the successful ones, only take certain size cases. So they may even tell you, I don't take a case unless it's $1 million and up. So if there's $2 million in damages, they might take it because they're getting a contingency fee. And there's a section on this that explains the types of fees, but most litigation attorneys do it on a contingency where they get 30%, 40% of whatever they recover. So if it's $3 million in damages, they're going to potentially get 30 or 40% of that as their legal fee. If they don't recover anything, they don't get anything. So if you have a smaller amount of damages or you're willing to pay, then you can hire a business litigation attorney who works hourly. That could be, depending on your area, the specialty, it could be $200 an hour. You go to a big law firm in New York City, you might be paying $2,000 an hour. Average might be around $400 an hour that you're paying, and you're paying for all of their time plus any court costs. So you have to add up what are the risks versus the reward. Okay, the risks are I'm going to be spending potentially a large amount of money, and I may or may not be able to get that out of the person. So business litigation attorneys look at how much money damages is there, how much can we recover, and even if I go to court and win, can I collect? So if you're going to sue someone, you might want to do some research on that business or person because what if they're broke and they just file bankruptcy and you just wasted all your time and money going to court that you can't collect on? So you have to make sure there's some kind of, they call them deep pocket, someone who has some assets you can go after, or maybe there's an insurance policy you can go after to make payment if you do win in court. So those are some of the things you need to look at is, okay, money damages, what am I suing for? And can I actually collect? If I'm able to collect and there's a fair amount of money damages, you might be able to find an attorney who just works on a percentage. You don't have to pay out of pocket. Otherwise, you're going to have to pay hourly to have someone represent you in civil court, because usually small claims is usually like $10,000 or less, depending on where you are. So if you're suing for $50,000 in damages, you're going to have to file a complaint in the local court, depending on the jurisdiction, probably where you entered into the contract, where the services were performed, where you're located. There has to be some basis for where you're filing. So you have to figure out, I'm filing in this county because this is where both of us are located. And it's based on this written contract. They didn't perform. They failed to do what they said they were going to, and it cost me $50,000. So there's your case. Then you figure, okay, well, $50,000 case, most attorneys are not going to take that as a contingency case. So you're going to have to pay hourly or do it yourself. Now, if you do it yourself, you could pay someone to help prepare some of the stuff along the way, or just do it yourself. Courts are set up to where technically you're supposed to be able to represent yourself, but judges might give you some leeway if you make mistakes along the way, but they're usually, depends on the judge, they're usually not too keen on someone making a lot of mistakes. So you have to know the local rules, you have to know the rules of court, the law, and be good at explaining it, both in writing and verbally to the judge if you're filing a motion or whatever, the hearings, trial. So you have to really be prepared if you're going to do it yourself in a civil litigation case. I've had cases I've litigated where the other side has represented themselves, and just depends. The judge might give them a lot of leeway, they might not, but usually you're allowed to represent yourself, except if you're a corporation, and this varies by state, but a lot of times if you're like a corporation, the CEO cannot usually represent the corporation because it's a separate legal entity. And a lot of courts will require you to have an attorney for the corporation or LLC. So you have to look at the court that I'm going to. Are they going to require me to have an attorney because I'm suing on behalf of my corporation? In that case, there's nothing you can do. You have to hire someone. So that's something you have to think about too. So can an attorney, do I have to have an attorney for this type of case? And you need to look at the local rules for where you might be filing this lawsuit. Look at monetary damages. How much am I actually suing for? And can I prove it? Is this something that I can collect on? If I get a judgment, can I actually collect from this person, or is it going to take a ton of time and money to collect? Now, there's one other area that you need to think about too. In contracts, you might see a provision that talks about attorney's fees. They call it an attorney's fee provision. If you're going to sue someone and you have a written contract, you want to look at the contract, read it, first of all, to see if you have a decent case or if they might have a defense so that they can get out of it and say okay, well, the contract said you were supposed to do this, but if, this happens, then they didn't have to. So you have to look at that kind of stuff. But it might have an attorney's fee provision, which says, if this goes to court, whoever wins gets their attorney's fees paid plus costs. So that's one of the risks, is if you sue someone for a business dispute and you lose, if the contract says they can recover their attorney's fees as the prevailing party, you've not only lost, now you have to pay all of their expenses and attorney's fees too. So something that's really critical when you're thinking about suing someone. And also on your side, if my contract says I can recover attorney's fees and it's a couple $100,000 case, it's probably worth taking it to an attorney, because they'll probably take it on a contingency if it's at least several $100,000 in damages, and there's an attorney's fee provision so that the other side is going to have to pay. And so not only do you potentially, if you win, get your couple $100,000 back, you've been represented by a professional who understands this throughout the whole process, and the attorney's fee, 30-40% that was going to go to the attorney, you might be able to recover from the other side to where you've been made whole. You don't even have to pay for your attorney, but the attorney still gets paid. So those are some of the things to think about. An average litigation case that I would take for a business dispute really depends on what location you're in. I was in California when I was litigating, and those, you never got away for less than 10 grand if you're paying hourly. I mean, it's more like 50,000, 100,000 and up that's going to cost you out of pocket to pay. I mean, just to file a case, to prepare it, file it in court, minimum 5 grand, if not 10 grand, just to hire an attorney to file the case. So you have to really think about, is it worth it? Is it just my emotion? Am I just mad at the person? Do I have a valid claim? What's the law on it? What does it say? What does the contract say if there is one? Can I recover attorney's fees if I win? And where am I going to bring this? What court am I going to bring this in? To see what their local rules are, to see, do I have to have an attorney if I'm a corporation, for example, to where you're forced to hire one? Are the damages enough to where, an attorney's going to be willing to take the case? If it's a relatively decent case and there's monetary damages in the millions that you can prove, the chances are you're probably going to find a decent attorney to take the case. So those are the things to think about. Hopefully this helps, and thanks for watching.